already. Ms. Brown, I have you all checked in. You can mute your microphone and wait for the judge to call upon you, okay?
Okay.
All right.
This is case number 21-158-550. This is Albion Funding LLC versus Karen Tarver. The matter is before the court, settling for a motion for summary disposition. Your appearance for the plaintiff in this matter, please.
Judge, could you pass me for one moment? I'm so sorry.
All right, Ms. Francis, we'll come back to you. Do I have
Thank you.
Ms. Tarver on this Zoom? All right, we'll come back to you, Ms. Francis. The court now calls case number 20. Court calls 21-142-677. This is Sun Secured Financing LLC versus Janet Vanderbilt. Vanderbilt is the last name. The matter is before the court, settling for a general hearing. This looks like a motion to compel garnishee defendant to respond to plaintiff's interrogatories. Your appearance for the plaintiff in this matter, please.
Yes, hi, good morning, Your Honor. Lindsay Malosa on behalf of the plaintiff.
All right, your P number, if you will, for the record, Madam Counsel.
Yes, it is P85242.
All right, thank you. It looks like I have someone in the courtroom who's related to this matter. Do I have Janet Vanderbilt?
Yes, sir.
All right, thank you. Good morning to you, ma'am. If it assists you with sitting down, you can certainly take a seat, ma'am. Good morning to you as well, sir. What's your name?
David Mendoza.
All right, thank you, sir. Again, good morning to you. This appears to be a hearing that relates to Apex Tax Solutions. The plaintiff in this matter, after having secured a judgment in this matter, is seeking information from the Tax Solutions entity in an effort to collect on the judgment. The record should reflect that a judgment was entered by default. That judgment was entered on the 24th of March of 2021. The total amount of the judgment upon entry was $896.92. Madam Counsel, tell me what's going on from your perspective regarding this matter. To you in just a moment, Ms. Van.
Yes, Your Honor. We had filed a writ of garnishment and it was issued and served upon Apex Tax Solution. They filed a disclosure stating that the defendant was no longer employed, and pursuant to Michigan court rule, we filed interrogatories upon the garnishee defendant, Apex Tax Solutions, just to gather more information. We were receiving conflicting information when we called and then what they put in their disclosure. And we followed up on this several times to try to avoid a court hearing, but we still have not received the answers to interrogatories. And as stated in our brief and motion, we have all the dates that we did try to contact them, as well as the fact that they have not responded, and also attached as an exhibit is the interrogatories that were served upon them. So at this time, plaintiff would ask that they be compelled to answer the interrogatories within 21 days and also pay an attorney fee of $350. And if they do not, then they would be held in contempt of that order.
Thank you, counsel. And I just noticed that the initial document that I was looking at did not have Mr. David Vanderbilt on it. And so I see that you're a defendant in this matter as well. Right. So what's going on here is, of course, there is a judgment entered, and this hearing today is in relationship to Apex Tax Solutions. Let me find out, is there anyone here from Apex Tax Solutions? Anyone on this Zoom? If you're on this Zoom, say something. So this does not relate directly to Mr. and Mrs. Vanderbilt, because this is regarding a writ for garnishment as to Apex Tax Solution, and then a follow-up on that with a motion to compel them to answer interrogatories that were sent to them. So it does not relate directly to the two of you. It relates to a third-party entity that the plaintiff is going after in an effort to try and collect on this judgment. what did you want to say to the board? Anything you wanted to bring to my attention at this time?
I have not worked at Apex since September of 2020. I'm not sure the pandemic was the reason we weren't really no money left. I'm not sure if it still exists. We were told by our attorney to come in today to say that we're filing bankruptcy, we should have a case number.
All right, so Madam Court Reporter, I hope that you heard Ms. Vanderbilt. She indicated that she hasn't worked at the entity since 2020. I believe you said September or October 2020. And moreover, she was indicating for the record that she and her husband are correct?
Yes.
That they're in the process of filing bankruptcy, and that the bankruptcy case number should be generated in the near future. Of course, the attorney in bankruptcy would be required to submit that document to the court. Obviously, those things are not before the court right now. This only relates to Apex tax solution. All right, and so if your attorney files the bankruptcy petition, then they'll send over a notice to the court, and that will state the proceedings in relationship to this while the bankruptcy is pending. All right, Madam Counsel, anything else you want to bring to the attention of the court before I make my decision on your motion?
No, just everything stated in the briefing here today, Your Honor.
All right, thank you. As it relates to the motion to compel answers to the interrogatories for we'll grant the motion in this regard and require that Apex respond to the interrogatories within the next 21 days, or be found in contempt of this court, required to answer the issue of attorney fees will be taken under advisement at this time. The court will set a subsequent date in regard to this matter to review whether or not the answers have in fact secured and what costs have been associated therewith. So I'm going to set a date approximately 30 days out to come back on this matter on the Apex part of this case. Madam Counsel.
May the 5th.
May 5th, that's going to be that date 5/5/22, and that's going to be at 9:30 a.m. May 5th at 9:30 a.m. All right, the court does issue an order to compel answers to interrogatories within 21 days. Madam Counsel, can you get something together and send it by way of email?
I sure can, Your Honor.
Now, let me give you the email address that you want to send it to. You ready for it?
Yes.
That's Latifah, LATIFAH dot, last name is Hunter, at 3636th districtcourt.org.
Okay, thank you, Your Honor. I'll get that over to the court.
Thank you. All right, so that's the next date regarding the Apex matter. If you, as you're submitting your petition in bankruptcy, that will state the proceedings against you. And so I will just await for the attorney to send over the petition in bankruptcy. They would send a copy to the attorney on the other side. All right, I wish the two of you well. Good day to you.
Thank you, sir.
Thank you very much.
Okay, thank you.
We're back on the record regarding the suffix 8550. That's LBNB Funding LLC versus Karen Tarver. And your appearance for the record regarding this matter, Madam Counsel.
Good morning, Your Honor. Nafjat Francis, P72322 on behalf of plaintiff's attorney of record.
All right, thank you, Ms. Francis. I'm looking now for Karen Tarver or anyone representing Ms. Tarver. If you're on the Zoom, please say something at this time. All right, the record should reflect the matter was set off from 9:30 a.m. It is now 10:14. This is the second call for Ms. Tarver. She had not appeared on the Zoom. I'm looking at the notice that was sent out. It was sent out to the address on Bishop Street that was provided by Ms. Tarver on her in her answer to the complaint. It has the correct Zoom address. The defendant was ordered to appear for this hearing at 9:30 a.m. Ms. Francis, anything else you want to bring to the attention of the court at this time?
No, Your Honor, we just ask for our motion to be granted at this time, Your Honor.
Just one moment, counsel.
I would note that at a previous pretrial in November, defendant had agreed to a payment plan. However, she failed to return the documents or begin her payments, initiating our motion for summary to be filed, Your Honor.
Thank you, counsel. Yeah, I see where in November, the court did enter an order dismissing the case without prejudice where the case was settled. And what you're saying is that the settlement agreement was never executed. And so in your motion for summary, you're asking for two things. One, you're asking the court, first of all, to reinstate the case because of the failure of the execution of the settlement. And secondly, you're asking for judgment based upon there being no genuine issue of material fact. Is that correct?
I don't think that we had actually dismissed the case, Judge, because she did not sign it. So I don't believe we filed it with the court. So I think the case was still proceeding.
I want you to take my word for it that there is an order of dismissal in the file.
Oh, sorry.
And I signed that order, I'm sure, when I heard that the parties had settled the case, that the court went ahead and set that order in place. And you're telling me based upon the facts as they actually are, that that order should be set aside, right, counsel?
Yes, Your Honor. I'm sorry, I misunderstood.
Now, the court will set aside the order of dismissal previously entered. That order not. The court now will find that there is no genuine issue of material fact in this matter. Moreover, that defendant has not responded to the motion for summary disposition, and additionally, defendant has not appeared in court on this date that was set for defendant to appear. The motion will be granted at this time, and judgment will be allowed in favor of the defendant, of the plaintiff, on the terms and conditions that's set forth in the complaint. All right, then you may submit your judgment as a part of your judgment. Simply indicate that the dismissal of, give you a specific date, the dismissal of 11/30/21 is set aside.
Thank you, Your Honor.
Right. And you have the email address already, correct, counsel?
Yes, Your Honor. I do.
All right, thank you, counsel. Good day
Thank
to
you, Judge. I have one more, but it's not till 10:15. So I'm guessing.
Let's see if we can do that. What's the last four on your number, on your case?
531.
Right, let's get to that. This is case number 21-160-531. This is Midland Credit Management versus Randy Corneal. The matter is before the court, set on for a settlement conference on today's date. This court set this matter up for a scheduling order. Looks like that was set up for the previous time. All right, counsel, your appearance. You're on mute at this time.
I'm sorry, Judge. Nafjat Francis, P72322, on behalf of Plaintiff's Attorney of Record.
All right, thank you. Good morning again to you. Do I have here Ms. Brandy Corneal? If you're here, say your name if you will.
Brandy Corneal.
All right, thank you, Ms. Corneal. You, I see that back in 2021, you did file an answer in this matter. This matter is before the court on the motion for summary disposition And it looks like the plaintiff, right, that, yeah, the plaintiff filed this matter. Did you file any written response to the motion for summary disposition, ma'am?
No,
Yes.
we actually,
Go ahead, talk to me.
I actually came up here last time, like November, and he had made up like a payment plan. They never signed off, and I never got no paperwork, and I called down here, and I called the court 2 times until they sent me 2 more papers telling me I gotta come back to court.
All right, so I don't know if you were able to hear Ms. Cornell, Ms. Francis, but she was indicating that there was a resolution reached wherein there was a agreement regarding payment. And I have a notation that the case was settled. It looked like I have an amount of $2,000. Is that what it was?
It was around that much, because I was paying was gonna pay money.
Yeah. That's a note that I have. And the defendant in this matter says that she never got the paperwork and has been waiting to get the paperwork to get this resolved. Counsel.
Your Honor, I don't have any notes about a agreement. So, if that was the case, I could definitely look into it. Don't know if you want to pass it or adjourn it. If I can get defendant's email address, if there was an agreement, we can email her the agreement.
Yeah, I have the notation in my file that there was a settlement and a consent order was to be sent in for $2,000. And the parties had talked about a payment arrangement on that. I don't remember any of the details of a payment arrangement, and I don't have that in my notes, but I do have that the parties reached a settlement the last time they were here. All right, so I will pass it. And what do you need, Madam Counsel?
I'll just check on it and then come back, Your Honor. If you were gonna adjourn it, I was going to ask for her email address.
All right,
But
so you got to check on it now, and then we figure out where to go from there. That's what you're saying, Madam Counsel?
Yeah, yes, Your Honor. I'm gonna try to reach someone right now.
Right, and let them know the court, that's the notation that the court has, all right? So ma'am, just be seated for a bit, and I'm gonna come back to this case, okay? Just, yeah,
Thank you.
Court now calls 21-241-201. This is Heaven Brown versus Car Source. The matter is before the court, set on for, it's like an initial hearing, I believe. This was a small claims matter that has been removed to the General Civil Division. For the, do I have Heaven Brown on this Zoom? If you're on the Zoom, say something at this time.
Yeah, this is her.
Okay. Good morning, Ms. Brown.
Good morning.
For the defendant in this matter, your appearance at this time, please.
Good morning, Your Honor. Ziad Cassett, 72237, representing the.
I'm sorry, sir. Go ahead. I thought I cut you off there. Okay, you're representing Car Source. Is that correct, sir?
Yes, Your Honor.
All right. So I did receive the answer in this matter, the affidavit and the claim regarding this matter. And in that answer, you point out that the car was sold as is with no warranty, and that was part of the transaction. Is that correct, counsel?
That is correct, Your Honor.
So, so Ms. Brown, did you buy this car as is? Is that what happened?
Yes, I did. I was aware when I bought it that it was a 30-day warranty on it. And that I could bring it back within that 30 days, and if anything was wrong with it, or trade it in or anything at that time, if anything was wrong with it.
Well, I'm looking at the sales transaction document. It has sold as is, no warranty. Which 30-day warranty are you referring to? Counsel, was there a 30-day warranty on this matter?
No, Your Honor. The was given an opportunity to purchase a service contract from a third party, and she declined at the time of the transaction.
Wait, I'm sorry, what?
So the indication is that that you could have purchased a service contract at the time of the sale, and that you declined to purchase a service contract. But what I'm inquiring about is the 30-day warranty that you said that you had on that.
Well, she didn't necessarily say warranty. The lady that does the paperwork that I was signed off of, I asked her, I was like, if anything's wrong with the car, could I bring it back? She said you have a 30-day limit to bring it back if there's any issues or anything. So during that time, I did have issues. Like the first day I had a broken headlight. I brought it back. And weeks prior to that, my battery died. I called about that. I brought it up there then. So they were letting me come up there and everything.
All right. And they corrected things during the 30 days. Is that what you're saying?
I'm sorry, what?
And you're saying that they corrected those things during that 30-day period?
Yep. They every time I called them within that 30-day period, they would see me and everything and fix anything that was wrong with the car.
So no, nobody gave anything like that to you in writing, though. Is that correct, ma'am?
No, I asked for paperwork for each time I went up there, but they never would give me any paperwork or anything to show that I was up there for whatever was wrong with the car.
Your Honor, if I could direct the court to Exhibit A of defendant's answer. It's the buyer's guide for the vehicle signed by the plaintiff. It says in big bold letters, as is, no dealer warranty. The dealer does not provide a warranty for any repairs after the sale. And then towards the bottom of the page, Your Honor, service contract is checked.
Yeah. I already looked at all of that.
Okay. Okay.
Making the inquiry I was making because the documents are very clear there. So after the expiration of the 30 days, did you try to get some additional assistance on your vehicle?
Yep. The issue that occurred during the 30-day period when I brought it back is the same issue that occurred two months prior to me bringing it up there within the 30-day period. My car completely broke down on me, and I brought it back up there, and I was still able to get seen, and they were telling me that they would help me pay for it. And then I ended up having to take it somewhere else because it was sitting too long at the dealership, and they ended up fixing it. And then when it came down to fixing it, he acted as if because I went and sued him that he didn't want to pay for it. But I was offered a settlement.
You
I
can't talk
talked
to me.
to.
Let me
Huh?
stop. No, you can't talk to me about a settlement.
Okay, sorry.
Yeah, don't talk to me about it. All right, so the challenge here is that it doesn't have a warranty involved in this case. Obviously, there was some exchanges that were taking place. You said that there were some discussions regarding settlement. Counsel, are you prepared to talk with this Brown to see if there's a way to resolve this case at this time, sir?
I did speak with her a week or two ago. We weren't able to come to an agreement. I have no issue. She has my phone number. She's more than welcome to call me. We can continue to discuss settlement, but if we can't resolve it, Your Honor, I've been instructed to file a motion for summary disposition. All
right. So here's what I'm going to do. You have a few challenges. Ms. Brown. So if there's a way to kind of get this settled, you need to see if you can get that done. But you have a few challenges. Are you listening to me?
Yeah, I'm listening.
Yeah, okay. So because of the fact that there is not a warranty in place, it looks like it's some extended effort, but there's no warranty. That warranty controls everything. And the purchase of the car with language as is, no warranty, that's really, really controlling language in the state of Michigan. So I want the two of you to take a moment to see if you can get this case settled today, because likewise, otherwise it seems like this may not work out too well in the long haul. Now it needs something that within that 30-day period that they started to put forth some effort, so that could have some meaning. The documents, the written documents, control this relationship in some significant kind of ways. Course of conduct, behavior can have some implications. So I want the two of you to talk and try to get this done today. It may not be what either side likes, and that could be a good resolution resolution. If both sides don't like it, it sounds like a resolution. Take a few moments. I will sit in here when you come back. If you're not able to get it resolved, I'll figure out the next step. There's your notification, sir. And Ms. Brown, your notification for breakout room number 1 was sent as well. And I'll be here when the 2 of you come back in. All right, let's see if we get this done. Thank you.
Okay.
Ms. Brunson, let me know when you're back now. It looks like, I see that you're back, Mr. Said, oh, Ms. Brown, I see she's coming back in.
Your Honor, you put us in the break room and I was sitting there alone.
Yeah, me too.
I waited a few minutes and I just came back.
Oh, what happened?
It was just loading. It wouldn't let us through.
Yeah, if you could try again, Your Honor.
Yeah, that's what I'm getting ready to do now. So
Okay.
there's Ms. Brown, there's your notification. And counsel, I'm moving from 1 to 2. There you go, sir. See your notifications, sir?
Not yet. Oh, here it is. Join breakout room. Got it.
Judge, could I
Yes, ma'am.
ask you on on the, on that file, what date you have those settlement notes from? We're having a hard time finding it.
They were from the last date, and I'll get that for you just a moment. Okay. And Ms. Francis, I believe that that last date might have been October.
She came, the last time she came to Portland.
Yes. This one.
In October?
Was 10/27.
10/27.
Okay, thank you, Judge. I'm just, they're just looking for it. It'll just be a couple more minutes. I'm sorry.
All right, not a problem. Not a problem.
Thank you.
welcome back, Mr. Cassett, Ms. Brown.
Your Honor, I had an opportunity to speak to the plaintiff. We are going to discuss resolution, I think, in the next either few hours or few days. She told me that she got a towing bill for a vehicle that she traded in as part of this purchase. I need to go back to my client. She's going to send it to me via email. I need to go back to my client to see what that's about. And I have Ms. Brown's phone number. So I'll be calling her once I find out what that's about to see if we can resolve it. And I instructed her that if we can't settle it, then I'll be filing a written motion to dismiss the case. And obviously she has the opportunity to file a response and plead her case before Your Honor.
All right, you said a written motion to dismiss the case. I understand that, and I'm sure that she understands as well. So I'm going to go ahead and set a control date on it.
Okay.
I hope that we keep talking because there's some issues on both sides, but again, as you know, pointed out very frankly that the written documents are so controlling when it comes to the sale and purchase of motor vehicles. So when you have language like, no warranty as is, and so on and so forth, that has very definite meaning. But again, the course of relationship has some implications here. So hopefully you can get it worked out with that, those issues being involved.
I'm going to try my best, Your Honor. My client's pretty reasonable, and if the plaintiff can be reasonable, I think we can resolve it.
All right, sounds good. All right, Ms. Brown, thank you for coming in. I'm going to set the new date now. Let's put it at 30 days out.
The same, okay,
Yeah.
5/5.
5/5, 22, 5/5/22 is going to be the next action date of this matter. It's going to be at 9:45 a.m. May the 5th, 9:45 a.m. And you will get something in the mail, but it's good to note that date anyway, 5/5/22 at 9:45 a.m. Right? So we'll see you at that time.
Okay, Ms. Brown, send me that invoice, and I will talk to my client, and I'll call you.
All right.
All right,
okay.
counsel, can I have your P number? You said it so fast.
Yes, it's 72237.
Thank you.
You're welcome.
Judge, could I ask Ms. Keneal what the payment terms were for that agreement?
Ms. Goodell, do you recall what the agreement was regarding monthly payment or something? I remember this case, but I just don't remember the details. I took that particular note. What do you recall was going to be the monthly payment numbers?
I'm not really sure what the deck amount was. It was like 100 and some change. I'm not sure.
She said they had come up with, she said she's not sure, but she said they come up with 100 and something, but she don't remember what it was, what the exact dollar amount. But I don't have that
Okay.
information. What I'm starting to recall is whoever was here, there was a discussion that they would come up with the amount afterwards, a payment amount, and I just don't remember. I didn't take a note.
And I apologize, Judge, they seem to not have written it down anywhere. So I am happy to put make an agreement with her now and put it on the record, and we could submit it as a conditional dismissal. What payment terms, what are you able to pay, Ms. Keneal? Sorry.
Last time when I came up with an agreement of the amount that I was gonna owe. And I don't remember what amount that he had gave me.
Well, I have the notation that the agreement amount was $2,000. Because the case is, the claimants were higher than that amount. I have a note in my file that the parties agreed to $2,000 settlement. The question is, what monthly payment are you asking to make on that? So we put it
Is it possible that this can be thrown out?
It could be thrown up to more than 2,000. Or it can be thrown down to the 2,000. Not likely that it's gonna be thrown out. It's not that kind of case. You have a debt. And I think that I don't remember all of what you did, but you negotiated something to be able to get it down to where it is. Because the plaintiff was claiming in this case. Hold on, I'm looking at summons. They were alleging damages of $4,800. And I don't remember all of what happened here, but there was an agreement to between the parties for 2,000 instead of $4,800. And this appears to relate to a Gardner White account. So
Yes, Your Honor, it was.
back in 2019. Yeah, throw it where? What are you talking about?
I mean, because when I was like only $200 behind when I tried to pay, I called, they told me that, oh, I just need to wait to get turned over to the deputy. Well, I tried to pay with them, they told me, oh, you just need to be a lawyer. And I came out here for that one court date, and I'm back out here again. For that court date. And that was back in 2019.
Your challenge here is that somehow, I don't know what happened, I don't remember the details, but somehow a claim for $4,800 is being brought down to $2,000.
Right. And no, that's why I said we came up with a great agreement. I remember you
Yeah,
said,
well, that's where we are now. You're
Yeah.
talking about throwing something out now. We're in agreement for $2,000. Question is, what monthly payment?
how long would I have to pay them?
Oh, no, talk to me.
And kind of keep them.
You gotta see if you can reach an agreement on that, you know. That part, we don't have the agreement right now. You gotta tell her, tell me what you'd like to do. Let's see if that's agreeable. If it's not agreeable, then you gotta negotiate something different. What it sounds like to me, it sounds like about $125 a month case. That sounds like the way to resolve it, but I mean, you know, you tell
I
me
take that.
what you think, counsel. Does that work for you? I suggested $125 a month. What, does that work for you, counsel, or if your client wants something more than that, or go ahead, talk to me. Ms. Francis, are you hearing me? Ms. Francis? Oh, I'm sorry, I was talking, I spoke with Ms. Cornell. She was coming up with an amount. I suggested that $125 a month sounds like about the right amount. But I wanted to know if that was acceptable to you, to your client, because it has to be agreed on.
I believe that would be, sorry, Judge, I was just looking through. $2,000 just seemed like it was a weird settlement amount. So they were saying they thought maybe it was 2,000 down, but I told them you had in your notes that it was $2,000 settlement. Is that what it said, or did it say 2,000 down? $2,000 payment.
What it says is that $2,000 settled.
Okay. Then we'll do the $2,000, and if she can do 125 per month, we'll do that, and we'll do it as a conditional dismissal.
Yeah, I don't have elaborate notes on it. What I have is $2,000 settled, awaiting order. That's what, and it has a note of consent. That's a note that I have from October. I don't know how the parties got to that or anything. If they tell me something a little different than that, like that's 2,000 down and then an agreement on the balance, I'm usually comprehensive on that. It's something, somehow they indicated that it was $2,000. I don't know what happened along the way. And, you know, I don't want to skew this one way or the other. I mean, I'm in the middle. That's the only note that I have. And it doesn't tell me anything beyond that. I was hoping that somebody else had noticed that might tell something different, but that's all I have.
And the attorney that appeared on it had no notes on it. So that's who I was talking to. So they said that 2000 seemed weird, but they had no notes, so they wanted me to check with you.
Yeah, I
They
mean,
didn't even, they had the last hearing date as September, so I think somewhere along the line that October date just somehow got deleted or lost, Your Honor. I think it was just like a clerical error and it didn't get written down.
All right, and you recall us reaching a settlement, right?
Yes.
Yeah, and I remember this young lady being here because you came to court instead of coming in Zoom. I remember that. I remember a discussion, there was the other attorney is a male, right?
Yeah.
Yeah, and I remember there being a discussion and out of that discussion, that's where my note came. And I was waiting in order at $2,000 settlement. Okay, all right, so you got the agreement for $2,000 with payments of $125 a month. And that payment, the first payment on this matter would commence on the 22nd of April. And then you would continue each month thereafter until the balance is satisfied. All right, and so Ms. Francis is going to send an order to me with those terms, and you'll get a copy of that. It will say that the parties agreed to a compromise of $2,000. And the way that those things work is you pay the $2,000 at $125 a month, and then the case is over with. If you don't make the payments, then it goes back to the original amount. That's how these settlements work, okay? So, you're down from that $4,800 to $2,000, but you gotta make that $125 a month so that you don't get it, they don't have the right to judgment for the amount in complaint. That's how it works. It's settled at $2,000, but if you don't make the payments as you're supposed to, they have the right to enter a judgment based on the default at $4,800 minus any payments that you understand.
Yeah.
All right, Ms. Francis, you got that?
Yes, Your Honor, we will email it to your email address.
All right, and then I'll sign the order and you'll get a copy of it. Make sure the 22nd of April is when you make the first payment, $125. Make sure you get it paid every month.
Where do I make the payment?
All right, and that
To-
is,
To Stanger
ahead.
and Stanger.
yeah, the information that you have on the paperwork that you said Stinger and Stinger. Okay, yeah. So you got something with the Stinger and Stinger address on, it, right?
No. This is the like
Okay, you have any other paperwork?
from Gardner White, contract.
Okay, here's what I'm gonna do. I'm gonna give you a copy of this document that has Stinger and Stinger PC.
Okay.
You send your payment to Stinger and Stinger PC, will be made out to Stinger and Stinger PC. Okay? You put the case number for this case on any payment that you send. All right, so I'll make sure that she has a copy of the address and everything for Stinger and Stinger.
Thank you, Your Honor. If she would like a website to pay online, I can give that to her as well.
All right,
Yes.
yeah, you ready to take that down? Sure.
Is she ready?
Yeah.
It's
Yeah,
stangerlaw.com is STENGERLAW.com. And then I can give her file number. It's
Yes.
M as in Mary, D as in dog, 010181.
all right, and that's regarding that's the office number, case number. For their case, okay, that's where you make your payments.
Okay.
All right.
Thank you, Your Honor.
You're gonna copy the order shortly. Or email. Thank you, ma'am.
Thank you, Your Honor. Sorry about the confusion.
No, I noticed good resolution.
I'm glad you had the notes.
Thank you. Ms. Francis. Good day to you.
Thank you,
also.
Judge. You as well.
I'm glad you had it for us.
Been up the creek. Yeah, and you know what I'm concerned about is that one case that she got divorced from something traditional. She said that that case was settled, but she never said.
Yeah, you did say you were waiting.
It's still on YouTube.